Under common law, a buyer of farm products takes the goods subject to a security interest created by the seller unless the secured party authorizes the sale. This rule is an exception to the general rule that a buyer in the ordinary course of business takes goods free of a security interest. In Clovis National Bank versus Thomas, the court considered whether a lender's conduct could waive its security interest. Clovis National Bank loaned money to W.D. Bunch twice. Each time, Bunch gave Clovis a security interest in several head of cattle as collateral. Later, Bunch sold these cattle and gave the proceeds to Clovis to pay his debt. Clovis didn't authorize the sales, but knew they were happening. Clovis usually allowed debtors who had pledged livestock as collateral to sell that collateral and use the proceeds to pay off their loans without Clovis's prior written consent. Bunch took out an additional loan secured by nearly 300 new head of cattle. In the security agreement for this loan, Bunch promised not to sell any of the collateral without Clovis's prior written consent. Thereafter, Bunch consigned cattle covered by the security agreement to Harold Thomas to sell at public auction on Bunch's behalf. Bunch didn't obtain Clovis's express consent to the sale, and Clovis didn't know about it. Bunch kept the sale proceeds. Clovis sued Thomas for conversion, seeking to recover the value of the cattle sold through him based on Clovis's security interest. The trial court ruled for Thomas, finding that Clovis had waived its security interest by acquiescing in the sale. Clovis appealed to the New Mexico Supreme Court.